Hello, everyone. Thank you so much for joining us today. My name is Craig Saperstein. I'm a partner in the public policy practice at the Pillsbury, Winthrop, Pittman law firm. I'm based out of D.C. And Pillsbury is so thrilled to be co-hosting this webcast today with our friends at Guidehouse on financial innovation and regulation, finding the balance. And we are particularly honored to have some very special guests with us today from the CFPB's Office of Innovation. And they'll be here to provide some details on what that quite innovative office is doing to promote financial technology and innovation in financial services more generally. So again, we want to thank everyone for joining. I think I will turn it now over to my colleagues here on the call to introduce themselves, because either I'll puff them up too much or I won't do them justice by giving my own introductions. And I did want to note my colleague Deborah Thornton-Peden is listed on the speaker list on the slides that you're seeing right now. But unfortunately, Deb was having some technical difficulties. So even though I think she's listening in, she's probably not going to be speaking today. But if Ed and Natalie and Alma, if you wouldn't mind introducing yourselves, that would be wonderful.
Sure.
Sure.
Well,
Let me think. Go ahead.
So I'm Alma Angotti.
Yes,
I am the sort of emerging legislative and regulatory risk lead for financial services at Guidehouse. And so I am very excited to hear about all the wonderful things going on at the CFPB's Office of Innovation. Thank you, Craig. Appreciate it.
Thanks.
And I'm Ed Blatnick. I'm the acting director of the Office of Innovation, also a founding member of the office. And I've been at the Bureau since 2012. And prior to being in the Office of Innovation, I was in the legal division of the CFPB.
Hi, I'm Natalie Prescott. I'm an attorney at the Office of Innovation, and I actually moved from Pillsbury to the office earlier this year. So I've been here for probably 9 months now.
Well, thank all of you. Really appreciate it. And as Natalie mentioned, we were so proud to call Natalie a colleague of ours at Pillsbury. And although we were certainly sad when we found out she was leaving us, we told her at the time that if there's one place that we would love to see her go, it would be to the Bureau and again to this very exciting startup office, the Office of Innovation there. So Ed and Natalie, thank you again for taking the time to speak with us today. So just really quickly, we don't have an agenda slide here, but what we're going to do is Ed and Natalie are going to walk everyone through what their office does and what progress they've made in a short amount of time running it. Alma and I will provide some other thoughts on the landscape surrounding financial innovation and how it interacts with regulators. And then we're going to go into some Q&A. Alma and I definitely will have some questions for Ed and Natalie on this. And if folks who are on the line want to ask some questions, we'd be thrilled to have you all do so as well by entering some questions in the chat box feature of this webcast. So with that, I'm going to turn it over. I'll flip the slide here. I'm going to turn it over to Ed and Natalie to provide an introduction to the Office of Innovation.
All right, thanks, Craig. We really appreciate this opportunity to spread the word about our office and our innovation policies, because the more, I think more folks know about what we have to offer, the more applications we expect to get under the policies. Let me just start off with a brief description of the office itself. The office was started in the summer of 2018 when the Bureau brought in Paul Watkins to head the office. He had been at the Arizona Attorney General's office and was responsible for the nation's first state sandbox in Arizona. And I and my colleague Albert Chang came on detail to the office at that time. So the three of us were really the founding members of the office. I think it's worth noting that most of our team is, like me, longtime Bureau employees who came from other parts of the Bureau. So as I mentioned, I came from the legal division. Albert came from the Office of Fair Lending. Our colleague Will Wade Gary came from the markets part of the Bureau. He was the assistant director for card deposit and payment markets. And our colleague Julie Vore came also from the Office of Markets, where she was in mortgage markets. And we have a director's financial analyst to help us. And we recently have another detailee, Mauricio Videla, who came from the Office of Supervision Examinations. And so really Natalie is the new blood in the office, and we appreciate her new perspective on things. I think it's important also to note that there is a very clear statutory basis for the Office of Innovation in our activities, and that's primarily Dodd-Frank 1021b5, which notes that one of the Bureau's objectives is ensuring that markets for consumer financial products and services operate transparently and efficiently to facilitate access and innovation. I think we like to say, and I think this is becoming increasingly the case for how most people think about the Bureau, is that facilitating consumer beneficial innovation really is just another tool that the Bureau has at its disposal to protect and help consumers. Everyone is, of course, familiar with enforcement, supervision, regulations, education, and engagement. But this is really just another way of protecting consumers, and we're able to do things that that the Bureau can't do through other tools. And here I've put on the slide here just a clear example is if there's an innovative product or service that promises to expand access to credit, for instance, to consumers, but it's not being offered because of some type of regulatory uncertainty, the Office of Innovation, through our innovation policies, which Natalie will talk about in a moment, can reduce that uncertainty. That product can get onto the market, and consumers who otherwise, because they're underbanked or unbanked and do not have a substantial credit file, may be able to get credit that they otherwise would not be able to get. And supervision and enforcement are wonderful things, but they're not going to enable that kind of access, right? So with that, I'm going to turn it over to Natalie to talk more about give an overview of our roles and responsibilities.
Sure. Thanks, Ed. So our main role in the Office of Innovation is just to implement the 3 innovation policies that Ed was just talking about. These are the no action letter policy, the compliance assistant sandbox policy, and the trial disclosure program policy. All 3 of these policies are intended to provide increased regulatory certainty to companies or others who are developing innovative products and services. Like Ed said, these types of services might not fit very well within our existing laws. Our office also coordinates with other regulators through our participation in ACFIN and GFIN. These are national and international networks of regulators that essentially periodically meet just to share information and best practices and generally work together to facilitate innovation that benefits consumers. We launched ACFIN in September 2019, and by now I think we have 19 state regulators who have joined. So that's been pretty exciting. GFIN, which is the global network, was launched in January of 2019, and that one now has more than 50 regulators from different countries. Beyond that, we also work internally with other Bureau offices on innovation issues and initiatives that are going on at the Bureau, maybe outside of OI. So the first policy I'm going to talk about is the no action letter policy. This is the current NOW policy. We did have a previous NOW policy back in 2016, but this current one was issued in September last year. And a no action letter states that under certain facts and circumstances, Bureau will not take enforcement or supervisory action against the recipient under the Bureau's authority to prevent UDAPs or any other described statute or rule that are under the Bureau's jurisdiction. When we get an application, we assess that application based on potential for consumer benefits or risks, why the applicant might need a NOW, and Bureau priorities at large, among other things. If you are issued a NOW, there's no temporal limitation on it, and NOW recipients are not required to share data. The previous 2016 NOW policy, recipients did have to provide data, but under this new one, that is not the case. But even without this data requirement, recipients still have a duty to notify the Bureau if there are any material changes to the application or information that the product or service isn't performing as anticipated. And of course, the Bureau just retains the ability to obtain information about products and services under its various authorities. Under all of the policies, and that includes the NOW policy, there is a template function. So this template function allows third parties to apply for templates. And these are legally non-operative, but they provide a framework for first-party applicants to use in their own separate applications. So for example, trade associations or consumer groups or service providers, these all might be good candidates for a template application. Trade associations in particular might apply for a template to enable innovation policy use by smaller members. The next policy is the Child Disclosure Program policy. This one is statutorily described in Section 1032 of Dodd-Frank. Under this policy, applicants can propose and then conduct in-market testing of innovative disclosures that might not necessarily comply with existing federal law. So this policy was developed with the understanding that a lot of the required disclosures just weren't designed for modern technology. And ideally, trials could result in improved disclosure requirements that better fit today's financial market. So if you're successful, the Bureau will issue you a TDP waiver. And under that waiver, you have a safe harbor to conduct testing of an innovative disclosure for a limited period of time. Under this waiver, the recipient is exempted from or deemed to be in compliance with disclosure requirements. So unlike the NOW policy, this one comes with data sharing requirements. Waiver recipients have to share data with the Bureau so that the Bureau can assess the effects of the trial on consumer understanding. And again, third parties here can apply for a TDP waiver template, which first parties can use for their own applications. And then our last policy is the Compliance Assistance Sandbox policy. It says issued September 2020, it should say 2019. But again, this facilitates innovation by providing an approval to applicants who will receive a safe harbor under TILA or EFTA or ACOA. The safe harbor is is, under the applicable statutory regulatory provisions for the conduct in question provided in good faith compliance. Again, this requires data sharing about the effects of the product or service on consumers. There is, again, a temporal limitation, the opportunity to apply for extensions, though. And again, there's the opportunity to apply for a template if you're a third party who wants to do that. And then I'm going to turn it over to Ed to move along here.
Okay, thank you, Natalie, and thanks for pointing out my typo of the 2020 and 20 instead of 2019. You're showing your value once again. I think the general story here is that we've been quite successful, and I think it's fair to say we've been more successful with our three policies than we even had hoped or anticipated. Really, under the 2013 original version of the trial disclosure policy, the Bureau never issued a single trial disclosure waiver, and under the original 2016 NEL policy, it issued one no action letter. And so since launching these policies last September 2019, 2020, we've now granted 7 applications, mostly under the no action letter policy, 1 under the compliance assistance sandbox policy, and we have many more in our pipeline. Just to very briefly summarize the topics of the ones we've granted to date. I mean, the numbers 1, 2, 3, and if I'll just jump ahead here briefly, 7 are all on the same topic of mortgage lenders providing funding to housing counseling agencies, and that raised an issue under RESPA Section 8. And so we began by issuing a no action letter to over 1,600 housing counseling agencies that participate in HUD's housing counseling program. At the same time, we issued a no action letter template that HUD had applied for that could be used by mortgage lenders as a basis for NAL applications on that topic. We then issued a NAL to Bank of America that had applied based on that template. That's number 3, back in January. And then more recently, in September of this year, we issued a second no action letter, this time to Chase, for interested in providing funding through its mortgage branch, providing funding to housing counseling agencies. So I think one of the notable points there is that the template process, which Natalie mentioned, has now been used and is shown to work well. The other ones we've issued, number 4 there, a no action letter template applied for by a trade association. BPI is sitting there providing a foundation for depository institutions to apply for a no action letter for their small dollar lending products. And we have such an application that is currently pending, so stay tuned on that. Number 5 is interesting because it's a no action letter template application from a service provider. Brace Software had developed an online platform for loss mitigation services, and was finding that mortgage servicers were somewhat skittish about adopting the platform because of certain uncertainties under Reg X. And so that template is there also waiting, serving as a foundation for applications. And then number 6 there is a template under the compliance assistant sandbox policy, and it has to do with employers interested in providing what are called autosave programs, so whereby the method that's been used for 401ks for quite some time, whereby an employer just tells the employee, hey, I'm putting some money in a 401k for you, but you can opt out, to apply that approach to emergency savings, which is one of the priorities of the current director. And we have a whole emergency savings initiative that's ongoing. And I will mention last but not least, as I mentioned, we have, I'd say, over a dozen applications that we're currently processing, and they cover a wide range of products and markets. And those are many of those are listed here on the slide I'm showing right now. So we expect to grant more applications in the coming months, and certainly remain doors open for anyone who has an interest in coming in to at least initially discuss a potential application. And so I know our time is limited, so at this point I'm going to turn it back over to Craig.
Thanks so much, Ed. Appreciate it. And actually, Alma, I think you were going to start by offering some of your own observations as well, but both on what Ed and Natalie have offered, as well as some of the other dynamics at play in the financial innovation arena.
Sure, Craig, and thank you, Ed and Natalie, for that. It was really helpful. So it's pretty clear that the pace of financial services is outstripping the old regulations and regulatory framework, right? I like to say that a lot of these rules were written when people only wrote checks and sent money by telegraph, right? And so the old system of local jurisdiction and local licensing made sense, and doesn't so much in a digital environment. Deb and I were on a panel discussion in London, and some of the participants were telling us that it is more difficult to do business in the US than in the EU because of the passporting of your license in the EU. So to grapple with that, there are a couple of competing initiatives going on the other end of regulation innovation, and that is the Conference of State Bank Supervisors are coming up in 2021 with a system of money services business network supervision, so that money services businesses and payments companies that do business in all 50 states won't be subject to 50 exams. I think for 40 of the states are banding together, so they'll only be subject to one exam led by one state with experts supporting him for cyber and AML, which makes a lot of sense in a digital environment. On the federal level, as I'm sure a lot of you know, the OCC has been experimenting with special purpose national banking charters to allow certain financial services businesses to have a national charter and avoid state regulation. They're in litigation with the Department of Financial Services over the charter that would cover lending and deposits, and they're thinking about one just for payments, which wouldn't have those two components. So lots more to come there, but I think it's good that the regulators are also thinking about how to make it easier, because the easier it is, the more innovation that you'll get. Craig, I'm sure you've seen a lot in this area.
Yeah, Alma, you've really hit the nail on the head with these dynamics. Clearly, state regulators are surveying the landscape and are realizing that both with the consideration of a special purpose national bank charter, for fintech companies generally, as well as this possibility, which has been announced but not really implemented yet, of a payment specific charter by the OCC. Obviously that's a threat to state regulators who appreciate their role in regulating, money services businesses and other related types of organizations. So that dynamic really is one to watch, but also the work that Ed and Natalie and the offices of innovation at some of the other federal regulators are doing is also a dynamic that is of interest to the state regulators as well. And I think that could kind of lead to one of our first questions for Ed and Natalie. So Natalie touched upon the fact that the Bureau is quite involved in coordination with both state level officials as well as international officials. as it relates to spurring innovation and finding that proper balance between innovation and regulation. I was wondering if, Ed and Natalie, if you could go a little deeper into with whom you've been working and what that coordination is actually looking like from a practical perspective, as well as your other coordination with the other federal regulators who, of course, some of whom have adopted their own offices of innovation as well.
Sure. And, I think as Natalie mentioned earlier, this type of coordination with other regulators is really one of the pillars of our office and the Bureau's interest in innovation generally. I think, particularly when it comes to no action letters, which are just a statement of the Bureau's own supervisory and enforcement authority, that leaves open the possibility of potentially of an action by another regulator. So coordinating with those other regulators is key to making sure that someone, a recipient of a no action letter, it doesn't face the prospect of an action from a different regulator, even though we've given that entity a no action letter. I think on the level of GFIN, obviously it's a difficult thing to have that kind of coordination at that level, but there is a lot of interest in it. There are a lot of members now. There are significant work streams of which the Bureau is a member. We're also a member of the coordination group of GFIN, and there's a cross-border testing work stream that we're a member of, and there's the second edition of that is currently underway. So that we're taking applications. GFIN is taking applications for companies interested in testing products in more than one jurisdiction. So if a particular entity wanted to have the U.S. as one of those jurisdictions, then the Office of Innovation would entertain that application. We're also a member of what's called the RegTech SoupTech work stream, and I know there's a lot of coordination going on among regulators on those fronts. That could be the topic of another webinar. Really, it's such an important, diverse area of issues. And so, as Natalie mentioned, we started based on the GFIN model. We started the American Consumer Financial Innovation Network a couple of years ago, or actually not a couple of years, last September, September 2019. And we had 8 members at that time, and it's really just federal and state U.S. regulators. And we've grown it fairly rapidly to 19 members. And in some ways, most importantly, we have the OCC as a member. And one of the things that the ACFIN members do is hold joint office hours. And we held joint office hours with the state of Utah back in January, actually in person before the pandemic. And then at the end of July, we had a 2-day virtual office hours with the OCC that was very successful. We had many applicants, some of which we had to turn away, unfortunately. And so that through those office hours is a way in which, all of the innovation components of both state and federal regulators can both coordinate and interact with industry.
That's really interesting, and the fact that you have 19 state partners for ACFIN in particular, I think is kind of interesting, because I think there's only I can't recall the exact number, but I think there's certainly less than a half dozen states that have actually implemented kind of their own sort of sandbox regime or some sort of Office of Innovation and Financial Services. So it sounds like right. Even beyond those states, like a Utah, like you mentioned, that have affirmatively implemented their own set of innovation policies. It's good to know that other states are getting engaged. And of course, some of you on the call may know that the state of California recently passed legislation that turns their Department of Business Oversight, which has been the traditional regulator for money services businesses in California, they are, via new legislation, they have created what some are referring to, Ed and Natalie may not refer to it this way, but what some are referring to as a mini CFPB. It's the Department of Financial Protection and Innovation. It's actually led by a former CFPB official. And in addition to having some of the similar authorities to what the CFPB has at the federal level, including authority over unfair, deceptive, abusive acts and practices for certain financial institutions, there is an innovation component, as the title of the new agency suggests, where there is going to be an effort to try to spur innovation in a state, that in many respects is kind of the hub of FinTech activity in California. We work with a number of California FinTechs. So that is definitely a development that folks should be looking out for, is that re-envisioned agency comes into being over the next few months. Alma, I didn't know if you had any other points you wanted to make on that, or if you wanted to move on to another question.
I think I'll move on to the next question because we have so much to hear from Ed and Natalie. So I think it's a real testament to your new procedures that you've already gotten a lot more applications just in the past year than you had previous to that. And I'm wondering if there's anything that has surprised you or made you think differently about a process or products, even though I know it's a little early to tell, but anything that you've learned from this, from the applications you've granted to date?
Yeah, that's an excellent question. I think one of the things that I've been somewhat surprised about, and I've already mentioned this, just the success of the template model, because just from talking to other regulators, both here and abroad, I don't think anyone has ever tried to do this kind of thing that we have with the template. So the process is really itself an innovation, and so we were not really sure how it was going, how much interest there would be in it, and even when we granted a template application, whether it really would serve as a foundation for follow-on applications. And I think we've been pleasantly surprised that it seems to be working, and it really provides a way for entities that are not themselves providing consumer financial products and services to make use of the policies. And so, as I mentioned, we've had a trade association, we've had a service provider, we've had another federal agency submit a template application, HUD in particular. And we even have currently an application from a law firm for a template, so which Craig may be interested to hear. And
taking notes for sure.
So there's, I think that's really one of the things we've learned. I think we've also learned, and that when we encourage in the policies companies to come in and talk informally about their idea, as opposed to just trying to submit a full-blown application such that we would then have to grant it or deny it. That has also proven to be a good approach, I think, because through that process we can gradually develop something to the point where it's ready to actually submit a formal application. Under all three policies say that once the Bureau deems an application to be complete and formal, that we will endeavor to process it within 60 days. And I think I can report that we've pretty much, with the applications granted today, we've pretty much met that goal. So that had been one of the complaints about the prior policies. There was no indication of how long it would take to process an application once one was submitted. And you have, especially if you're a startup or really any company who wants to do something innovative, you want an answer quickly so you can get your product into the market. You don't want to have it held hostage by a federal agency. So I think that's another thing that we think has worked pretty well.
And I'll just add on to that. So one of the surprising aspects for me so far has actually been the pandemic, and how it's sort of brought to light how urgent the need is for some of these new innovative products and services. Just for an example, when we issued the small dollar loan no action letter template to BPI, their application actually brought up the fact that consumers are right now more in need of small dollar responsible credit during the pandemic. And we've already gotten some interest in follow-on applications from other institutions who want to make use of this template. So that's been kind of surprising and a little bit gratifying to me to be a part of that.
That's very interesting, and it really is great to hear about the quick success you guys have had in a pretty short amount of time. So we've obviously I would suspect both Alma and I have spoken to clients of ours about potentially participating in one of your innovation policy programs. And one of the first questions we often get from our clients as they're thinking about this is, what information about the product or the service or the disclosure that's in question will actually be disclosed to the public, and what information that's submitted both in the application and during the data collection, if some sort of whether it's a sandbox or a trial disclosure or a no action letter, what data collection is discoverable under the Freedom of Information Act, the so-called FOIA. So it'd be really helpful if you guys could just kind of explain how the office aims to protect proprietary or confidential information that is shared with you all in connection with an application or for participation in one of these innovation programs. Yeah, because of course, you have a lot of FinTechs in particular who have some brand new innovation, and they don't necessarily want the whole world to know their whole secret sauce.
That's right, the secret sauce problem. I mean that's also a great question, because I can tell you we heard that concern loudly and clearly about the original two policies. Both of which did not say a whole lot about that. And so if you look at each of the three policies that we issued back in last September, at the last section of each of them has a very extensive section about confidentiality issue. I can say, one thing to keep in mind is that we're not going to disclose anything, voluntarily disclose anything in policy until the point at which we actually grant the application and issue the no action letter if it's under that policy, and issue some version of the application. Prior to that, everything is not made public. There's always FOIA lurking there as a potential way of exposure, but we actually go into some detail in each of the policies, explaining why we think that most, if not all of the information submitted by an applicant during the pendency of an application should be protected mainly under Exemption 4 to FOIA for confidential business information. I think we also note in the policies that there was a recent Supreme Court decision, which unfortunately I'm blanking on the name of right now, that it was very helpful in this regard, that cleared up a lot of complicated DC Circuit case law in that area. And so I think that contributes to our confidence that that information shared during the application process would remain confidential. And I think that would, that extends to under this is not mainly an issue for the no action letter policy, but for the other two policies where there is data sharing by the recipient. The same thing generally applies. I think the only thing to note in this regard to have folks keep in mind is that, if the information shared, and this is especially true in the trial disclosure policy, if the information shared about new disclosures being better increasing consumer understanding relative to required disclosures. If the data shows that, then the Bureau would be interested in using that data to actually change the regulation. And of course, if we do that, then we're going to have to cite the data in some fashion in the rulemaking. Now, I think there are potentially ways to just use aggregate data and try to make it somewhat less than obvious who the source of that data was. But I think that's something to keep in mind, and it's something that would be worked out when we discuss what we call the terms and conditions document of for the trial disclosure waiver.
Alma, did you want to ask the next question?
Sure. So I was actually going to ask about the trial disclosure policy and what would happen if you, after you decide that the trial disclosure was good. So I'm so glad that you went into that. So I do have a different question. It kind of involves trying to understand how these different policies are going to work together. For example, how are advisory opinions different from no action letters and some of these other innovation policies, and how do you expect them to interact with each other? Or what's the interplay between them? Because there's a lot going on.
Yeah.
I can take this one. So this is a great question. We do now have an advisory opinion pilot program that went into effect at the end of June. And this AO program, this is intended to allow stakeholders to request interpretive guidance to resolve regulatory uncertainty again. And under the pilot, covered persons or service providers that are under our supervisory or enforcement authority, they can submit a request for an AO to resolve that stated uncertainty. And so first, AOs don't necessarily deal with innovative products and services, although they of course can. And unlike the approvals under the sandbox or the waivers under the trial disclosure program, AOs are interpretive rules under the Administrative Procedures Act. So AOs are going to apply much more broadly, not just to the requester, but also to anyone whose situation conforms to what's said in the actual advisory opinion. They'll also note where a statutory safe harbor applies. But all of this suite of products, of policies, there are multiple products and services or requests for certainty that could apply to all of them. We will often work with a potential applicant and listen to where they're having concerns or issues, and we can even say, hey, we think that this would fit really nicely under this policy, or we've heard about a lot of uncertainty under a particular statute from many different players. So we think maybe this could work well for an advisory opinion, that kind of thing. So it's definitely not like a lot of these will apply to a lot of different things. And so we like to speak with potential applicants to sort of figure out the best way to go there.
Yeah, and then I'll just add, going back to Alma's point about the pace of innovation outstripping the ability of regulators to deal with it. I think one way of looking at that is that if the only tool the Bureau had to deal with that was rulemaking, we would just be lagging, very, very far behind, because as everyone knows, the rulemaking process is a very lengthy process for, many reasons, which we could go into, but it has a lot to do with DC Circuit interpretations of the APA and so forth. Because if you go back and look at, rulemakings in the early 70s, they're like 12 pages, and now we're like up in the 1,200 pages area for some of these rulemakings or more. But these tools that the Bureau has developed, and we may be trying to develop more in the future, are really ways to provide some sort of regulatory assistance, compliance assistance, clarification about how regulations apply in particular circumstances on a much more nimble time frame, right? So that's why we very much built in the 60-day provision to the policies. And I think similarly, if we get a request for an advisory opinion, the goal is to, and we decide to issue that advisory opinion, the goal is to actually come out with it in a pretty timely fashion. We're not going to, the Bureau and other agencies, its predecessor, especially for many of the statutes, the FRB, often use the notice and comment for basically interpretive rules, even though it's not required under the APA. And so our advisory opinions, we're not going to use notice and comment. And that's really the main reason why, because we want to provide clarity on a more timely basis.
Well, thank you, Ed. So we have noticed that we've gotten a few questions from our audience. So we're going to move on to some of those. And thank you all for asking them. And if anyone else has any questions, please feel free to put them in the Q&A box below. The first question we had is, if we obtain a TDP waiver, a trial disclosure policy waiver, are we also safe harbored with regard to state disclosure? And if not, how can we rely on a TDP?
Excellent question. I'd say, unfortunately, the safe harbor that's provided by a TDP waiver, just as is also true of an approval, the safe harbor that's provided by an approval under the sandbox policy is just limited to federal law, because that's what's within the Bureau's jurisdiction. So, if it's a particular provision of TILA and Reg Z that you're asking for the waiver for, and you're basically saying, I know this is not compliant, but I think it's better than what you require, and that waiver will basically be an exemption from that provision, that requirement, and so you would, by doing it, you would not be, because you have an exemption, you are not breaking the law, and there's no basis for the Bureau or anyone else to bring a lawsuit against you. But yes, if there is a copycat provision in state law, that we just don't have the authority to exempt companies from state law requirements. At that point, we would the applicant could request that we coordinate with that state on that issue, and especially if that state was a member of ACFIN, then we would be hopeful that even though we can't exempt you from the state requirement, the state would not sort of see this as an opportunity to bring an action against you based on state law. More ambitiously, for states with their own sandboxes, potentially you could apply for some kind of relief from that state itself, and simultaneously, have a federal safe harbor and a state safe harbor. I'm not claiming we're doing that next month, but that's potential. That's the potential that ACFIN promises.
Well, I have to say, Ed, you are certainly whetting my appetite with your slight little previews of things to come. I know you need to be discreet and not revealing coming attractions for new initiatives for your office, but you're definitely touching on some things that I think we're going to want to revisit as we move forward, because you guys I know are trying to remain on the cutting edge and to adapt as you learn more in accepting these applications. So another audience question we had was, what is the difference between a now and a now template, and how do we learn more about the approved or denied no action letters to date?
Yeah, I think the best way to understand the difference is to look at the granted applications, and the ones that I mentioned earlier. They're all available on on the innovation page of the Bureau's website. If you go to that page, near the top there'll be a link to the granted applications, and you can look at, you could just begin at the very beginning the first one there, and you could look at HUD's application for both ANEL, for the housing counseling agencies, and it's up in the second part of its application for ANEL template that could be used by mortgage servicers, and see what each type of application looks like. Again, the policies themselves really give detailed instructions for what to include in an application for ANEL, what to include in an application for ANEL template. And then when we issue an ANEL template, it likewise gives fairly detailed instructions to potential applicants based on that template of what to include in their application. And you'll see that, for instance, the Bank of America application for ANEL based on the HUD ANEL template, hews very closely to what that template instructs. So as Natalie mentioned, ANEL, just to stick with the ANEL policy, but this applies to the other policies as well. ANEL is an operative document. It basically says the Bureau tells the recipient, we are not going to bring a supervisory or enforcement action against you, and you can rely on that. It's operative. It has real force and effect. A template, as the policy say itself, is not operative. Just saying, here's this framework that we're issuing. It's almost like a kind of policy statement in its own right that says, if you want to apply for a real no action letter, an operative no action letter based on this template, here's how you go about doing it. So that, I think, is the main difference. And I think there was like a second part, or the last part of your question, Craig, which I'm forgetting at the moment. So could you just remind me what that was?
Yeah. The second part of it was how do you learn more about the approved or denied nails to date? And I think you kind of
I guess I did answer that.
Yeah. So kind of one last question for you, Ed and Natalie, before we let you go today. And Natalie touched on this a little bit a few minutes ago, but I think it's worth revisiting. So if you are, let's say, a FinTech who's looking to participate in one of these programs, if you are a bank or a credit union who has some new innovation that you're pursuing, what should be the very first step that you take in finding out what your options are, and just generally speaking, how other than talking to your lawyer or your compliance expert like Alma and I, how would you start if you are a company who's interested in participating in one of these policies?
Sure, I can take that one. I would say absolutely start with the policies themselves. So those are on our application or on our website. And there's also the granted applications. You can take a look at those, and you can see generally how the policies work just based on looking at all of those. Then typically, of course, after speaking with your legal counsel and everything, typically potential applicants will get in touch with us. You can just shoot us an email that's on the website as well. And then we will set up a time to preliminarily discuss what it is that they're thinking about. And these can be really informal discussions. You don't have to, provide any kind of preliminary application or anything like that. Sometimes potential applicants will bring along like a slide deck that kind of explains what their product or service is. But we'll just talk through your product or service. We'll talk through which of the policies might be the best one for your application. And then we'll get the ball rolling from there. So we love having people come talk to us. Again, you don't have to have anything formal or anything like that, just to run some ideas by us.
Yeah, I would only add to that the in terms of the overall timeline for getting an application granted, the more you have ready when you first come to talk to us, that is likely to speed the process along. I mean, I think it's just you need to find the right balance. Like, you don't want to put a huge amount of time into drafting an application and only to find out that for one reason or another, we don't think we can do much for you under any of the policies, or for whatever other reason. So I think you want to just have like an initial discussion, make sure that we think that there's some, the application has some legs, as it were. But then once I think, the two parties agree that this is worth pursuing, then the more quickly the applicant can get a draft of the application in place, the more quickly the whole process will move.
Great. Well, I just want to say thank you so much for joining us today. And I think it's very exciting because, as Craig said, we see clients struggling all the time with wanting to do things and truly and honestly wanting to do it the right way and just not having a good sense of what that is. So when you see the regulators really striving to help them accomplish that, I think it's good for everybody. And so thank you again for coming. Craig?
Yeah, I'm sorry, Ed, did you want to say something else?
Oh, no, I was just going to say, repeat that I very much appreciate the invitation to get the word out about our about what we have to offer. I think when we are very much, we're now over 2 years old, so maybe I don't know what the period of time is for when you stop saying you're a startup. Maybe there's something in the FinTech world about that. There's like some official period of time, but I think we still feel very much in startup mode. And I think when we first issued the policies back in September of last year, we just thought, everyone is going to know about these policies, and we're just going to get hundreds of applications. But it's really just a process of having events like this where we have an opportunity to let people know about what we have to offer. We're really kind of, I've never really I've been a lawyer for most of my career. And even prior to that, I was not in business. I was definitely not in sales. But since being in this position, I definitely feel like we have our three products, our three policies to sell, and we're out there trying to drum up interest. And so far, I think we've been pretty successful. But events like this really give us an opportunity to spread the word further.
Well, Ed and Natalie, we are so honored to have the chance to speak to you today, and we hope everyone who listened in valued it as much as we did. Because I know that I've learned a lot during this presentation. And by the way, if we're talking about kind of innovation parlance, with all the great work you guys have done, I think you guys deserve to be referred to as a unicorn. I think we'll use that terminology, because you guys have done a lot in a very short amount of time, and we look forward to seeing how your work continues to evolve going forward. We want to thank everyone for joining us today. We're so pleased to have the chance to speak to you. If you want to contact any of us, please feel free to use the contact information that's on this last slide. This presentation has been recorded and will be made available to those who registered. So you'll be able to hear Ed and Natalie's wisdom, as well as Alma's. I will not include myself in that category. You'll be able to hear all their wisdom going forward if you want to listen to this again. So thanks so much to everyone for joining us, and we'll look forward to speaking to you again next time. Bye-bye.